general, right? So blue is like a general domain where this examiner is active within. So 49% in general, looking at all cases in this domain, would have at least one, which means many get closed before many get issued without sending out any letter. So again, this is our friend here from the previous slide. Right? So he's way below on the second and so on, the average of those two communications issues are. So this probably is useful for you to understand, or your attorney to understand, before he approaches an examiner or deals with the case. And then, because what we also did was not just to find the names and process steps, we actually digitized all of the letters themselves also. Not just the letters that the examiner sent out, but also the response letters that attorneys submit. Right? Because we can just, you don't have to admit that. Once we found a great argument, we'd probably like to reuse it. Right? So this is one examiner, the green box, sorry, is application number. So in one case, he cited this decision. It's a case law decision, right? This is one of the appeal boards, they will say something. And he said, you know, we don't need to go further here. So he justifies his decision basically by citing this case in this sentence. Blah, 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 does not require further evidence. I rest my case. I cite decision T172/03. Goodbye. He did it again. He did it again. And I don't want to bore you, he did it 52 times. And only one of those cases survived to grant eventually. Now, wouldn't it be interesting to understand, what did that one guy do that succeeded? That law firm, that lawyer? What if you could verify your argument before you submit your response letter? Again, there's no need to reinvent the wheel, obviously, right? Because it's not the first time he's sending out that argument to you. He's done it 52 times. So you're saving also him a lot of time. You're making the whole process more efficient at the end of the day. Because they get overloaded. What do you think happens if you beat the 53rd guy with the same issue? He won't be happier. Right? So there's, in my opinion, there's always an element of people negotiating here. We cannot just ignore that fact. Right? And once we start accepting that fact and try to use the data also in the legal industry, we can not only make our counsel better, more strategic, but probably also make process more efficient. Because if I save you 1 year, it could mean the world. Because why do we do all of this? Let's not forget, we don't do patents for just fun. They're more affordable hobbies. There's a lot of money behind it, lots of it. So when I was the chief IP counsel, you know, the CTO would come, or some R&D manager. What's the status of that patent? Because that patent or those patents protect maybe the most significant innovation we've done over the last 5 years. Millions and millions of R&D money spent. If that is sold successfully, salespeople get their commissions, get their bonuses, everybody's happy in the company. So people tend to forget that. They get, you know, they dig down and they say, oh, my patent prosecution is great, but we try to achieve a business goal here by getting that patent granted. And if you talk to startups, right, from a startup perspective, it's really expensive. So the more efficient I can make it, the better. Or maybe the data will tell me, you know, maybe I should just drop it now. Okay, I tried, but at some point we have to accept also it's probably not possible. So yes, you can do a prior art search for sure, but you should not ignore these other data points that can help you drive the process more efficiently. The same thing can happen to you in appeal. So the appeal is the last instance you can save the case. So you go to appeal. Once you fight with an examiner, you argue back and forth, and you're like, no, I mean, this is not going anywhere. You can file an appeal. This is the last chance you have. And what happens today a lot is that lawyers try to cite, so that green one, that 33614 there, is another decision. Depending on the topic, you will cite a decision to just justify your argument. And if you're lucky, you will know that this decision was cited by this board. And what I mean by board is like they have these cryptic numbers. So you will be going, if you're an attorney, you'll be going to board 3.501. And every attorney knows what's going on. Right? And then you find some old case that the board 3501 issued, and you cite it, and you said, but this board itself said this. And then of course the board members will say, yeah, that might be the case, but it was a board in a different composition. There were other members sitting on that board back then. We don't care. I mean, they don't say we don't care, but essentially that's what they mean. Right? It's just too much at stake, in my opinion. Right? So you should go find what did that board actually say. And not only what did that board actually cite, so this is a chart, you can actually in our platform build the exact composition of these 3 board members by name. You can select them. And then we show you an overview of their activity. So on the left-hand side, you have the article 123.2, and trust me, every attorney knows what this is in Europe. It's not so important here. So it's a legal article in the European Patent Convention, in the law book. And here are all of the decisions these 3 board members cited in connection to that article 123.2. So if I now have an article 123.2 issue, let's say, you don't have it every time, just to be clear, but if I would have it, I probably want to understand how they've been thinking in the past, wouldn't I? And again, I mean, we're researchers. Like, if you start a new project, what do you do? Literature study. Or do you just say, oh, well, let's just start writing a paper? No, you wouldn't. And of course, experienced attorneys, they know, but I doubt they can know all of the little detail. When did that guy cite what? And the thickness of the branch means how often they cited it. So maybe there's a way between them. So this maybe just this occurrence 1, I think, if I remember. And you see the top 2 ones were cited more frequently. So if you don't have that much time, at least do yourself a favor and look into those 2. Because once in that room in front of those 3 guys, it's done. You don't get a second chance at the appeal stage. So that's basically it. So where we finally arrived is what we call the IPCon stack. So we have different modules, how we distribute the product now, not physically, but how we make it accessible to our users. Because some of the elements, some type of attorneys need, some of the modules, other types of attorneys need, right? Depending on what your focus area is also. There are specialized attorneys that just do appeal cases within a law firm, so you want to slice and dice and make it accessible to them. So we are right now the only ones that have ever been able to analyze to this depth with respect to the European Patent Office. So we can not only go in and say, okay, this examiner had this many workload and so on, but also see the arguments, right? But more interestingly is, how is the flow of arguments between the lawyer and the examiner? And there's still a lot of work to be done, right? And that's where, in the next phase of our company, the even more high value work will be done. But already giving these tools to some of the attorneys out there creates a lot of laughter in a good way, because they're surprised what's possible, right? Haven't seen it. Many have been waiting, been curious about it. Many also tell us, like, yeah, I knew there was something like this going on, right? Because they have this perception that, why is this examiner so difficult versus the other? On the other hand, we're helping the examiner because some guys realize, okay, it's me. Maybe I need to back down, right? So definitely, in my opinion, the future of law is digital. So if you would have asked me, how does this look in 5 to 10 years? I don't think there would be much value in the lawyer sitting from 0 to 100 and doing everything. Probably systems will recommend to them what to do, at what stage of the process, in view of which text space and so on. And they would basically select the arguments and submit them. It will be way more standardized probably in the future than what we have today, because basically today everybody is reinventing the wheel every time they make a submission. That's it. So we have time for questions now.
Questions? I have one question regarding a little bit the scope of what you're looking into. to. So if I understand, you actually, well, basically analyze events or decisions, I would call them somehow events, and you put a lot of emphasis on this relationship between attorneys and the patent decisions and patent offices. And like intuitively, so I would have thought that there you need to add more like content, like okay, specific, let's say, cases or like or perhaps context. Let's put it context to these decision making. Is that something that you aim for?
So let me see if I understand the question correctly. First of all, so do you mean like not just giving numbers, basically?
So for me, yes, it's descriptive statistics in a way about how the process and very process oriented in a way. And I would have expected. So obviously, since IP and patents are about content, are about specific type of ideas. I would have expected more, let's say, analysis also of this context in which this patent decision is taking place, or the context of the product idea that is being submitted.
I know what you mean. So today already we can let the user drill it down to a particular technology field which sets a particular context, right? You don't want to do statistics across in the entire activity before the patent. That doesn't make any sense because a chemical decision has no or little relation to software. But you got to start somewhere, right? We have been really busy just trying to come up with the data set and start analyzing. But what is really important to us though is that we don't just on the platform we don't just give access to the numbers. This is not a stock exchange and it's not like gonna change like crazy to next year. So we always allow the user to drill down into the actual arguments. So when we give you okay, we found that this was cited 22 times. With one further click, we give you actually the snippets where we identified this. And then you as an attorney still need to make the decision making. We just provide the tools, right? We don't make recommendations what they should say and submit. But then we show you this why we identified those, and then you will be able to understand the context we found them within. And there's more work to be done for sure, but we do already let them today understand where we got the data from and how it relates to that particular topic.
And what would be a typical, let's say, question the attorney would start using your tool with? More like searching about this particular patent?
So it kind of depends what they want to do, which task, but if we would say, if you're at the appeal stage, which is the last chance to save the case, they would usually, if his case or her case has a legal issue, they would want to understand those three people I'm facing, what have they said before? It's that simple sometimes. So it sounds very simple to somebody outside our industry, right? But you're coming from a step where there's nothing, you're just going blindly, and yes, those experienced attorney would say that I know my guys, right? I've been here so many times, which might be true, but there's always something to learn. Yes?
I have another question. Something like as I get it, your company provides help more to the IT attorney side, right? To make the process more efficient, maybe make more patent go through. But at the end, if only one side is using the data, it gives a bit like an externality in the process. So I guess ultimately a stable process would be that the whole system would be data driven. So is also the patent office using digitalization? What would they do? And at the end, is your vision that at the end the whole process should be just based on data? Could we reach that and then we don't need that attorneys anymore?
So I want to live another year. I won't say that I want to replace the patent attorneys out there, but they won't like me. No, so that's not our goal. We want to help attorneys become more efficient and help them achieve their goals and to grow their side of the business and help their clients. The patent office itself is trying to become more digitized. So if you read the strategic plan, 2025, they have some goal to, so the patent office right now, and this is just my interpretation of their strategic plan, but anybody can go read it, right? They have various databases. They don't have a single index, so to speak, if we use this language, where everything is in one so-called knowledge graph maybe. So they're working on what they call in that paper a virtual examiner. So actually they're creating an advantage for their side because they're sitting on all of the data, right? So if we wouldn't be doing this, it's the other way around. The attorneys would be even more, with a drawback. So although we didn't want to wait to 2025, so I think by the end of this year we will be able to have collected all of the relevant data in one single index, right? So we're probably a couple of years ahead of them already, and in next year we're going to start even deeper analysis. Don't want to go into too much at this stage already, but we will go even deeper, so that, but not with the purpose of replacing an attorney, but making them more efficient. Because what's also true in corporate world, again, this is a business behind the scenes, right? If you go to, and this is probably true for any department, but for legal departments also, that's what I can speak from, there are less and less resources, but more and more work. So we all talk about IoT, smart buildings, but if you take a look at legal data, it's also increasing. There's just no way that just humans can, do this in an efficient manner down the road, right? So they have to have these kind of tools sooner rather than later. So that's how we look at it, and we just want to augment and help them to become more efficient and be more strategic.
And do you have like a measure of this improvement in terms of efficiency? Do you try also to?
Yeah, this is something we will try to do in the future. Correct. So we're still a young company, right? But this is definitely some of the to-dos on our list, to work with some of our clients to see, okay, can you confirm to us what is missing maybe? I mean, we also have to be honest about this, right? We're not sitting here and standing and saying we know everything. Because only then I think you will fail as a company if you really think you know everything. We don't. We wanted to start somewhere, and in my personal opinion, you cannot just do this and go, what do you need? This famous quote, right? If you ask the customer, they want just a faster horse. I believe I'm on that side. And you could not, you just have to build this, you have to take the risk, you have to build it, and then hopefully inspire others to join this process and say, hey, good job guys, but could you also do this? And then you can start having a discussion. And we see this happening already now. But we had to trigger this process in our opinion.
Just one little question in the conversation. Is the database that you create dynamic, so it updates itself anytime that the platform is?
Yeah, so we update continuously, yes. So this is a great question, right?
Because it can change also as well the behavior of the examiner. If the examiner sees that he's going to be, he's too tough compared to the others, he might change the strategy and we need to update over more than.
Correct. So this is one of the big tasks when you do these kind of things, you need to update them, right? I think we you could probably do some of this one time, and there are people in the room that are more experienced than me in building these big data kind of solutions, but keeping it up to date, that's really the trick here, right? Efficiently.
Do you have a plan for the
Yeah, we don't push an update every week to the platform, right? So, it's new, maybe once a quarter, maybe once a month later, it depends, that we can decide. For us it's important, we know it works, we can do it, we can control that, and then we'll see how fast and how often we push it. Because there's one more important thing, I think it's also kind of interesting. So the way we look at the world is, we want the user to spend as little time as possible on the platform. Ideally in the future they don't even log in, because we will know what they need. So it's different to other type of platforms, because these, again, and people tend to forget this when they build applications on, what's your end goal? Well, the attorney needs to make money. Let's just face it, there's nothing bad about it, right? Because if you have a good attorney, you want him to survive, because he's helping you also to make money if you get your patent, right? So we want to make that attorney more efficient. How do we do that? He spends little time on platform, but can still maintain his billing hours and his revenue. And again, it's not a bad thing, because you want that good attorney to survive and keep helping you, because if they help you, you will make money in your business through the patents, hopefully. So that's one other aspect.
Questions? Yes.
Sure.
Can you address the quality of the patent somehow? I mean,
Yeah.
as you mentioned, and I've seen a couple of cases where the company has a patent, and actually when the going gets tough, the patent doesn't actually protect at all. So, and you can assess the quality, whether it really protects the thing or not.
Yeah, so that's,
You look at whether there's litigations, whether it holds, can you follow up also the quality?
so we can follow up, and this will be one of the new solutions we can offer next year. When we look at the European Patent Office, we will be able to tell you, because this is one of the questions also we get a lot. So if I go to appeal from this examiner, what usually happens? Does the Board of Appeal confirm the examiner or overturn? Because this could save you 2 years at least, if you know this before you go. Right? Because people, and again, this is also what we try to do, I keep saying, repeating myself, but it's also making the process more efficient, right? Because it might be the attorney that you just realize it's her or it's him, right? We just need to be more objective when we do these things. So this is something we can, this is something we're working on. But the other question is like about the patent claims and how good is that claim. This is also, we have got some ideas on that, but this is something we do later. But as I said already, we're gonna build some KPIs, and you could hint a bit, as I said before, I maybe want that examiner to review my patent, or if I know that examiner that has a low grant rate reviewed my patent, maybe that has a better impact on the quality of the patent. Because what I would be very concerned about, I would like to know as a patent attorney, I mean, it's a good feeling to submit a patent and oh, it's granted, you run off to the client, it's great. But what if you know that 99% of every case that the examiner touches gets granted right away? That would not be such a good feeling, in my opinion.
Is there anything with one more follow-up?
Sure.
On the speed, I mean, how fast the examiner works? And,
Yeah, we have KPIs for that as well. But that, so that's similar to the grant rate. I don't like to focus too much on the grant rate alone and not too much on these, because many other factors that influence it, right? For me,
you have all the timestamps.
yeah, of course.
So you can do that.
Yeah, of course.
Did you have a question also?
It's probably too early, but have you thought about applications to other areas of your approach? Legal action in general?
Correct.
Managing regulations?
Yeah, we would love to do that as well. Yes.
Okay.
So we have to start somewhere, right? Is when you, and again, from a business perspective, we raise money and so on. If you try to conquer the world right away, you're going to fail. So you have to select a space and be very comfortable with this space. But there are way more attractive fields than the patent field to do this on. Right? So we've been with law firms where other partners set in that are not patent, and they're like, why don't you do this for our space? So if the data is out there, now we built most of the process. Of course, there will be some adaptation for that legal topic and so on, but we would love to explore other fields in the future. Yeah.
Yeah. One thing which was surprising at least to me is I would have expected young examiners to accept more than experienced ones, right?
They have to trade on something, right?
I would exactly. So then that comes to my question. So, do you somewhere consider that maybe the examiners are actually dispatching the patent request based on that? In other words, those that are fairly easy to reject, they would give them to the junior one, which would then explain why the juniors, because like I said, I would expect an experienced examiner to be tougher to convince than a young one, right?
Yeah, that's a good point.
So seeing your graph sort of surprises me, and I'm thinking maybe they're dispatching the request so that the easy rejection go to the guys who don't have to be that tough to reject them. So there's kind of a paradox effect. The better patent requests go to the more experienced examiner, therefore more accepted.
But it's a similar case with paper reviews, right?
Exactly.
All the professors know, they accept more, whereas the young student accepts rejection. So probably you accept more than you should. You are more lenient.
Well, that's true.
So,
it's the same thing too.
but I don't know, so I know too little about how they distribute the work. I don't think they distribute it like that.
I don't know, yeah.
Yeah.
Just
But it's a very interesting observation. I was just thinking, okay, I mean, they're practicing. And there's a bias to rather reject than to grant at the patent office. We know that
Okay.
because there have been some quality efforts by the previous president at the EPO and so on. So there's been a big topic, right? That
I think Michalis is right. When you ask your PhD students to review papers, they tend to be tougher because they don't want to look soft, right?
yeah. It's a
So
good
they
point.
tend to be tougher.
We fed this AIDS smooth economy.
Yeah, I love that.
All right, so
There's
please.
one more
Oh,
question.
yes.
So building on the question about other areas in the law, so I liked your presentation because I fully agree that the law is really not databased usually. And in law school you learn things and your teachers tell you, okay, the cases on, I don't know, spatial planning laws for expropriation are very difficult to learn. But you never have data, so very difficult. What does that mean? Is it 25%? Is it 50%? And we have, so there are tools like Swisslex that are very good at inventorying data, but, so I haven't used it in a while, but when I was using it, when you look for something, it's great, but it does not provide you with any insight. Do you know, so you said that ideally you would like to expand to other areas of the law, but do you know whether Swisslex or other vendors are also looking at providing statistics on what cases, or is it something that, so do you see that this does not exist, or did you still see initiatives from?
So if you look at the United States, there's a lot happening there, way ahead of us. I mean, they think we live in the Stone Age probably, right? So if you speak with like they have some things there, they will ask us and we're like, sorry, there's no data. And they're like, what? There's no. So they can't believe it, right? Other European efforts in other areas right now, we're not monitoring that space so much. I wouldn't be able to answer that. But I think what we are trying to do here is really like the level of detail we can go down to. That's what you're also addressing and confirming, right? The level of detail we go down to is kind of exceptional at this moment. But I only, in this way, I think, because you really need to be assisting the attorney and not just giving statistics. That's nice, that's important, that's great. But as you just said, when they really work and you want to make them more efficient, you have to be able to go all the way down. That depth is really important. And as long as you cannot get somehow access to that data, you're probably wasting your time.
All right, so
Okay.
please help me thank the speaker.